In the United States, elder financial exploitation costs Americans over $28 billion every year, and in 60% of those cases, documented by the Consumer Financial Protection Bureau, the person who caused the harm was not a scammer, not a stranger calling from overseas. It was someone the retiree trusted, often a family member. I'm Frank Mercer. I practiced retirement law for 35 years, estate planning, social security disputes, Medicare appeals, trust litigation. What that practice taught me is that the most dangerous financial risks in retirement don't come from the stock market. They come from ordinary conversations, things people say casually and with good intentions that activate legal and financial consequences they never saw coming. Before I go any further, what I'm covering today is educational based on 35 years of practice. It is not legal or financial advice. Your situation has specific variables that matter. Always consult a licensed attorney or financial advisor in your state before taking any action based on what I cover here. What I'm going to walk through today are 5 specific things you should never disclose after you retire. Not to your children, not to your advisors, not to your caregiver, not to anyone, unless they are on a very specific, very short list. By the end of this, you'll understand why financial privacy in retirement is not paranoia. It's the same legal discipline that protects every smart business owner. You'll know the mechanisms that make disclosure dangerous, and you'll have a concrete framework you can act on immediately. If this kind of information is useful to you, subscribing takes 1 second. No products, no sales, just what I learned over 35 years that nobody told me to share. The numbers here are worth sitting with. The CFPB's 2023 Elder Financial Exploitation Report puts average losses at $120,000 per victim. Total annual losses exceed $28 billion, and again, 60% of perpetrators are family members, not con artists, not strangers on the phone. The people sitting at the Thanksgiving table. The FBI's Internet Crime Complaint Center reported in 2023 that Americans over 60 are the most targeted age group for financial fraud. $3.4 billion in losses that year, a 20% increase from the year before. Average loss per victim, $33,115. That's 3 times the national average for all age groups. The American Bar Association Commission on Law and Aging documented that in contested will and trust cases, undue influence is now the most commonly litigated claim in the country. And in cases where heirs were aware of estate plan details before the grantor's death, undue influence claims increased by 34%. Not after fraud. After a conversation, after the person who built the estate decided to be transparent with their family. I've seen this pattern more times than I can count. Clients who were sharp, generous, deeply loved, and who shared financial information out of genuine care. That information created expectations. The expectations changed behavior, and by the time anyone recognized what was happening, the legal situation had moved somewhere very difficult and very expensive to reverse. The 5 categories of information that carry elevated risk in retirement each activate a different legal or financial mechanism. In most cases, the person sharing has no idea any of that exists. The first is how much money you have saved. The mechanism here is what the elder law community calls financial exploitation through information disclosure. When a retiree reveals specific savings amounts to family, to neighbors, to financial professionals they haven't yet fully vetted, they create something that functions legally and practically like a financial asset. The information exists now. It can be used. Think of it like leaving your front door open and telling the neighborhood you're going on vacation. Most people won't do anything with that information, but the one person who does will cost you everything. The CFPB data is unambiguous. The average exploitation loss is $120,000. In cases that proceed to estate litigation, where families end up contesting a will or a trust because financial influence was alleged, legal fees alone average between $50,000 and $200,000. That's not the loss of the exploited assets. That's just the cost of the legal fight. Family members who learn specific savings amounts don't always act with bad intent, but they do act differently. Inheritance expectations get activated. Caregiving behavior shifts based on perceived reward. Subtle influence campaigns begin, usually so gradually that neither party recognizes what's happening. This is why the CFPB data shows family perpetrators at 60%. Not because families are predatory, because financial information in the wrong configuration changes any relationship. The second thing, and this is the one that surprises most people, is what your estate plan says. Who gets what? What the trust document provides. What the beneficiary designations look like. The legal mechanism is called undue influence. Courts examining contested estates look at 4 factors: the susceptibility of the person who made the plan, the opportunity someone had to exert influence, the disposition of that person to exert influence for an improper purpose, and a result that appears to be the effect of that influence. What's critical to understand is that courts don't need a confession. They look at the pattern, who was present, what changed, who benefited, and I have watched wills and trusts get thrown out, assets redirected entirely contrary to what the person actually wanted, because the pattern was unmistakable. The ABA Commission finding is the piece of this that I want every retiree to hear. When heirs know the details of an estate plan before death, undue influence claims increase by 34%. That's not after fraud, that's after transparency. The well-intentioned conversation about who gets what creates the conditions for exactly the conflict it was meant to prevent. Telling your beneficiaries the contents of your estate plan before you die is like a poker player showing their cards mid-game. You've given every other player at the table the information they need to play against you. Who is most at risk here? Retirees with blended families, unequal distributions among children, estranged relatives who might be surprised by what they find. These are the fact patterns that, once the information is shared, become the most expensive to unwind. The third category is your Social Security amount or your claiming strategy. This one surprises people because it sounds harmless. What's the risk in telling someone what your monthly check is? The mechanism is unsuitable financial product targeting. FINRA, the self-regulatory organization that oversees broker-dealers in the United States, reported more than 3,400 unsuitable annuity complaints involving retirees in 2022 alone. Median losses $47,000 per victim. The most common pattern, a retiree discloses their Social Security income to a financial advisor or insurance agent. The advisor uses that number to calculate the retiree's income floor at the stable base they can count on. That calculation tells the advisor how much retirement savings are theoretically available for a product purchase, because the monthly income needs are already covered. The product that follows that calculation is usually a deferred income annuity. It pays the salesperson 6 to 8% commission. It locks the retiree's capital for 10 to 20 years with surrender charges that can run 15% or more in early years. It underperforms a basic index fund by 2 to 4% annually over that same period. Before any first meeting with a financial advisor, broker, or insurance agent, any meeting, prepare a list of what you will and will not share. Investment goals, yes. Risk tolerance, yes. Time horizon, yes. Specific account balances, no. Social Security amount, no. Estate plan details, no. Not until you have verified whether that advisor is a fiduciary, which in plain terms means they are legally required to act in your interest, not theirs. And not until you understand how they are compensated. The question is simple. Are you a fiduciary and how are you paid? If they can't answer both parts of that question clearly, the meeting is over. The fourth category, that you've made gifts to family or moved assets. This is where Medicaid planning comes in, and the mechanism is one of the most costly traps in retirement law. Federal Statute 42 U.S.C. Paragraph 1996 PC gives Medicaid a 5-year look-back window. When someone applies for Medicaid long-term care coverage, the program reviews every asset transfer made within the 60 months before that application, every gift to a child, every loan that wasn't documented, every time you added a name to a deed, every charitable donation above Medicaid's gift threshold, all of it. The average nursing home cost is $9,884 per month, according to the Genworth 2023 Cost of Care Survey. The average lifetime long-term care cost for a 65-year-old woman today is $172,000. Medicaid was designed to address precisely these numbers, but only for people who qualify under the look-back rules. What most people don't understand is that casual conversations about gifts create legal records. If a retiree mentions to a nursing home social worker, a caregiver, or an insurance coordinator that they gave some money to the kids or put the house in the children's names, when that conversation becomes part of an intake record. I've seen Medicaid applications where the denial letter quoted what the applicant said during an initial facility tour, months before they ever thought about applying. That casual comment became evidence in a formal audit. The average Medicaid ineligibility penalty period created by improperly planned transfers is 19 months. At $9,084 per month, that's $182,096 in nursing home costs that would otherwise have been covered, not because the gift was wrong, because the disclosure was premature and unplanned. Generosity in retirement has a disclosure cost. Giving money to your children is not the problem. Talking about it to the wrong person at the wrong time is the fifth thing. And this is the one that in 35 years of practice caused the most damage by the widest margin, expressing that you're lonely, confused, or feeling isolated. This is the least obvious item on this list and arguably the most dangerous. Research from the National Academies of Sciences documents that social isolation increases by 50% in the first 2 years after retirement. That's not a small shift, it's a structural change in how people spend their days and who they spend them with. And in that context, someone who steps into that space, a caregiver, a new romantic partner, a neighbor who suddenly becomes attentive, can very quickly become the most influential person in a retiree's life. Legally expressed isolation is one of the 4 factors that courts examine in undue influence cases. It's the susceptibility element. An attorney representing a contesting heir doesn't need to prove bad intent. They need to show that the conditions for influence existed, and a documented pattern of expressed loneliness, combined with a new relationship and a changed estate plan, is exactly the pattern that wins those cases. The cases that broke my heart the most in 35 years weren't the ones involving strangers or scammers. They were the ones where a lonely retiree found someone who seemed to genuinely care, and didn't realize until it was too late that the caring had a price. Caregiver intensifies contact. Retiree updates the trust to include the caregiver. Family contests the estate after death. Legal fees, $50,000 to $200,000. The estate goes to litigation instead of to the people the retiree actually loved. Here's the part of all this that genuinely frustrated me for 35 years. None of these institutions, not the nursing homes, not the financial advisors, not the estate attorneys who didn't specialize in elder law, had any legal obligation to tell you any of this. The CFPB data on family exploitation is public. The Medicaid look-back rules are federal statute. The FINRA data on unsuitable annuities is a matter of record, but the system is not designed to surface this information at the moment you need it. The financial services industry benefits from disclosure. The long-term care industry benefits from intake conversations where residents share financial details. None of that is illegal. None of it is malicious. It's just how the system is built. You needed to know this before the conversation happened. Most people find out after. Everything I've covered is meant as a framework, not a substitute for professional guidance. If you're dealing with estate planning, trusts, Medicaid planning, or any of the specific situations I've described, take this to a qualified professional and work through it together. Here is the framework. Here is the first priority is what I call a financial information diet. Decide now before the next conversation happens who knows what. 3 tiers. Tier 1, full access, is your estate attorney, your fee-only fiduciary financial planner, and your CPA. These are the professionals legally required to act in your interest, and complete information is how they protect you. Tier 2 is your spouse or partner and any adult children to whom you've made a deliberate, specific decision to share specific things, not everything, specific things. Tier 3 is everyone else, other family members, caregivers you're still evaluating, advisors you've just met, new acquaintances. Establish this before your next family gathering. It costs nothing and prevents most of what I've described. The second priority is to instruct your estate attorney, in writing, that no information about your estate plan, your assets, or your beneficiary designations is to be discussed with any third party, including family members, without your direct written authorization. This is attorney-client privilege. Your right under the Restatement of Law Governing Lawyers. But you have to invoke it explicitly. Many attorneys will respond to family inquiries in good faith, assuming you have no objection because you never told them otherwise. Put it in writing, review that instruction annually and after any major life change. The third priority, before any first meeting with a new financial professional, prepare what I call a meeting script, a list of what you will share, investment goals, risk tolerance, general time horizon, and a list of what you will not share until you've verified fiduciary status and compensation structure, specific account balances, social security amounts, estate plan details. Ask the question before the meeting begins. Are you a fiduciary and how are you compensated? A fee-only registered investment advisor, one registered with NAPFA, the National Association of Personal Financial Advisors, is the only category of financial professional in the United States legally required to act in your best interest. Everyone else is held to a suitability standard. Know the difference before you disclose anything. The fourth priority is to ask your estate attorney about an in terrorem clause, sometimes called a no contest clause, in your trust. What it does is disinherit any beneficiary who contests the trust without probable cause. It creates a legal and financial disincentive for exactly the kind of post-death challenge I've been describing. Enforceability varies significantly by state. Florida, Indiana, and Georgia have limited or no enforcement. Require your attorney to confirm your state's current case law on this provision, but in states where it is enforceable, it is one of the most powerful protections available against the undue influence litigation pattern. The fifth priority, arrange for an independent third-party review of your financial accounts, quarterly, by a professional with no financial interest in your estate, an attorney, a CPA, or a trusted advisor whose only role is oversight. The research on elder financial exploitation is consistent. Early-stage exploitation, caught in the first year, is recoverable in most cases. Exploitation that goes undetected for 3 to 5 years often is not. Begin this within the first 6 months of retirement, not after a problem surfaces. We started with $28 billion in annual losses, and a statistic that reframes the entire risk. 60% of perpetrators are family members. The evidence shows that ordinary conversations about savings, estate plans, social security income, gifts to children, and personal isolation activate legal and financial mechanisms most retirees have never been warned about. The protection framework is a financial information diet, attorney-enforced confidentiality, a meeting script for financial professionals, a no-contest clause in your trust, and independent quarterly account oversight. What separates people who protect what they've built from those who don't is rarely how much they saved. It's whether they knew these rules existed before the information was already out there. Everything I covered is public record: CFPB data, federal statute, ABA commission findings, FINRA enforcement data. The framework the law already provides, explained the way I'd explain it to a client. After watching this, make a list of 3 people who currently have access to your financial information. Ask yourself, do they need to know what they know? If any of those people are also named in your estate plan, call your attorney this week. The law is far better at preventing this harm than reversing it. Comment below with your question or your specific situation. I read every one. They guide what I cover next, and if this was useful, sharing it with someone who's navigating these decisions may be the most valuable thing you do with it today. I'm Frank Mercer. Keep asking the right questions.